Yes, this is Bert Drosh, planning for the city. I believe we're ready to go. It looks like all 6 of the 7 board members are on. We're just missing Nathan, but he may be joining us shortly.
Okay. When we get to roll call for any item we have to vote on, we'll just double check on that. Okay. All right. I'm going to go ahead and try to start my video here. Okay. All right. Good afternoon, everyone. My name is Mel Pins, Chair of the City of Des Moines Zoning Board of Adjustment. I'm just going to have video on here briefly so we can welcome everybody to the hearing here today. Try to make this as personable as possible. There are just a few differences because we're doing this through Zoom online, but the general hearing itself will follow our same procedure. So just for kind of this preamble and opening statement, I just wanted to welcome everybody with a smile here today. So I'll go ahead and begin here. Again, good afternoon. Welcome to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear and make decisions on requests for variances and exceptions from the regulations in the zoning ordinance, to review conditional use permit requests, and to consider appeals from any decision of city staff in their administration of the zoning ordinance. The members of this board are citizens of the City of Des Moines and have been appointed to this board by the City Council. The board members are volunteers and they receive no compensation for their public service. I'm going to take a minute here and go through the names of our board members. We have 7 board members. They include Justin Gross, Dave Gare, Lynn Carlson, Marlis Jones, Cindy Smith, Nathan Blake, our vice chair is Nathan, and my name again is Mel Pins, chair of the Zoning Board of Adjustment. I'm going to introduce our city staff here as well briefly. They're helping us sometimes behind the scenes, so you may or may not hear from them today. Legal counsel to the Zoning Board of Adjustment from the city is Judy Parks Cruz. Michael Ludwig is the planning administrator. Bert Drost, planner. Sue Ann Donovan is the city's zoning enforcement officer. Tyler Hall is our meeting moderator. Dolores Rosino is also our meeting moderator. Eric Lundy, city planner. Jason Van Essen, city planner, and Catherine Dostart, city planner. I'm going to briefly go through our meeting's procedure. Again, this is basically the same procedure that we would have whether we're all live together in one room or doing this here by telephone or computer connection. While this is an open public meeting, this is a formal hearing. Procedure is being recorded for both video and audio. The board members have each received a copy of the agenda and the staff recommendation. The board is required to base its decision on each item upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case has been identified in the written staff report. If the facts, as demonstrated by this board, demonstrates that the criteria established by law for granting the relief has been satisfied, then the board must grant the relief. Otherwise, the board must deny the requested relief. We will announce each item in the order that it appears on the agenda. Items listed on the consent portion of the agenda, which is the first portion of our agenda, are not planned to be individually discussed. They will be considered for approval in accordance with the recommendations in the staff report, unless the appellant does not agree to the conditions recommended by staff, or if there's an individual or board member that requests that the item be removed from the consent agenda so that a full discussion on the matter can occur. And I will come back to this in just a minute as we do get to that consent agenda in order to help everybody through that. For the regular portion of our agenda, after an agenda item is announced, staff will first give a brief overview of the appeal. They will present any written comments received prior to the hearing. Then the applicant or their representative will be allowed up to 10 minutes to present their appeal. We will then move to the public comment portion of the hearing. Anyone who wishes to speak in support of the appeal, in opposition to the appeal, or maybe they're just neutral to the appeal but would like to address the board, they will then be allowed up to 5 minutes each to present their comment. This will be their one and only opportunity to address the board. So we will let people know when the appropriate opportunity is present for them to address the board, but outside of that, there will be no questions or answers or opportunities for folks to give comment. If you wish to speak on the item at hand at the appropriate time, if you're participating by Zoom, click on the raise hand icon, the little hand palm, on the participants panel. Again, if you're participating by Zoom, click on the raise hand icon that you'll see on your participants panel, usually on the right side of your screen. If you're participating by telephone, you can press the star key and then the number 9, and the meeting moderator will then know to call on you. Again, if you're participating by phone, when the time is appropriate, when I call for comment, you can press star and then the 9, the number 9, star 9 on your phone. When it is your turn, either by Zoom or phone, the meeting moderator will unmute your microphone through this application, and that will acknowledge that it is your turn. If you are using any documents or want to refer to any graphics or presentations, you must ensure that you send them by email to planning@dmgov.org. So planning, PLANNING, at dmgov.org. Once again, that's planning@dmgov.org. Once all concerned citizens have spoken on an item, the board will then ask for if there are any additional questions of city staff from the board. And lastly, the applicant will be given 3 minutes for a rebuttal or other closing comments if they so choose to give those comments. All speakers are required to begin their presentation by giving first both their complete name and address. If you're here as a resident or live or work at the address in question, you can give that address. If you're here in a professional capacity as an attorney, engineer, architect, or contractor, you can give your business address. So again, we need both your name and address prior to you giving your comments. All speakers are requested to remain courteous and to focus their comments only upon those facts that demonstrate whether or not the criteria established by law has been satisfied. Speakers are also asked to ensure that they are respectful of time consideration, and if necessary, the board chair will limit further comments by a speaker if they exceed their time limitation. And again, the applicant has 10 minutes to present their case. They'll also be given a 3-minute rebuttal. In between, anyone else who wishes to speak in support, opposition, or even with some neutral comments on an item, they'll be given 5 minutes. The board will then close any further public comment on the agenda item. The board will immediately deliberate the request, and we will make a decision here today. Please note that it takes at least 4 affirmative votes for any zoning appeal to gain approval. If your appeal is approved today, we ask that you wait until next week if you might need to contact the city's Permit and Development Center to obtain any necessary building permits for anything approved here, so that the decision of the board can be documented in the form of a decision and order. That decision and order will then be provided to appropriate city staff, and you will receive a copy as well. Any appeal that is approved by this board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision by this board, or such approvals shall expire. The decisions of this board can only be appealed in the Polk County District Court. If you believe you have been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the city council to change those regulations for future consideration. Any material written or otherwise used today as part of any presentation will become a permanent part of the record and will not be returned. So please contact city staff after the hearing if you might need a copy of anything that was referenced in today's process. We also ask that you keep your microphone on mute while staff is going to try to help moderate that. Please keep your microphone on mute other than when addressing the board. This will limit distractions during the hearing that is in progress. We also ask that within the Zoom format, you refrain from using any chat or question and answer functions, so don't type in any questions or comments as part of this hearing. That could be construed as what's known as an ex parte communication, and it will not be considered in this hearing process. So that's kind of our intro for this. Again, we will help everyone through the process here today, but what we'll do is we'll go ahead and we will go to our agenda, and I'll turn it over here to Bert Drost to help us get started.
Mr. Chair, members of the board, Bert Drost, planner for the city. On today's agenda, we only have one consent item, and that is for a conditional use at 2501 Garden Road. Staff has recommended approval of the conditional use, and so that's the only item eligible today for approval via the consent agenda.
Okay. Bert, can you make that just a shade larger on the screen? Is that possible to do?
Yes, it is.
Okay, all right. So item 1 is on the consent agenda. Do we have anyone present here today, either by telephone or within the Zoom application, that is opposed if the board would consider approval of this conditional use permit at 2501 Garden Road? If you would be in opposition to us considering approval for this, if you're by phone, please hit star and then 9, or by Zoom, hit the raise hand function, and then we'll have one of the staff members get you queued in here. So again, anybody here in opposition to potentially granting a conditional use permit at 2501 Garden Road related to item 1, please either raise your hand through Zoom or hit star 9 on your phone to be recognized. And I'll say going once, going twice. Is there any member of this board that would be in opposition to potentially granting approval for the conditional use permit? If there is, we can take that item off the agenda if you have any questions or would want to hear that item directly. Is there anybody from this board with any concerns on item 1? Okay, seeing none, would there be a motion to grant approval on item 1, basically granting approval of the consent agenda? Would there be a motion from one of our board members?
I move to grant that.
Would there be a second for Marlis's motion?
I'll second. This is Nathan.
Okay, all right. So we've got a motion from Marlis, a second from Nathan to grant conditional use permit approval for item 1 subject to staff recommendations, which would also by default be approval of our consent hearing agenda. All those in favor from the board will take roll call. Say aye or nay.
Nathan Blake.
Aye.
Lynn Carlson.
Oh, aye.
Dave Gare.
Aye.
Justin Gross.
Aye.
Marlis Jones.
Aye.
Cindy Smith.
Aye.
And Mel Paynes.
Aye.
Motion carries 7-0.
Okay, all right. So if you were here for item 1, that decision and order will come out to you probably first of next week with approval on that. And then if you have any further questions on those approval conditions, you can talk with city staff. So, so item 1 has been approved. Okay, so we'll move on to the regular portion of our public hearing. Our first item up for consideration is an appeal determination for related to 1922 Ingersoll Avenue and Lamar Outdoor Advertising of Iowa Incorporated. So this is an appeal determination. Let's see. city staff will present an introduction on this one, and then we will hear from the appellant, Lamar. So I'll turn it over to city staff to get us started on item number 2.
Members of the board, this is Sue Ann Donovan, the zoning enforcement officer for the city of Des Moines, and I will be presenting items 2 through 6 this morning. These sites are independent of each other, but all of the issues and the process and the appeal questions are the same. The addresses are 1922 Ingersoll, 2724 East University, 4337 Park Avenue, 3519 Hubble, and 215 University. Since there aren't independent facts specific to the individual sites, I would like to ask the board, with the consent of Lamar, to consolidate the hearing. That will save time and keep things moving and keep our facts straight.
Okay. All right. What I would like to do then is, before we hear from our board members, I would like to hear from Lamar Outdoor Advertising to see if they might be willing to consider that, or if they might prefer or concur with that as well.
Yes, this is Will Reasoner for Lamar Outdoor, and I concur with Ms. Donovan that items 2 through 6 should essentially consist of one presentation from each side, and should be decided by the board together.
Okay. All right. Thank you, Mr. Reasoner. Then back to the board, I think, to make this official. If there's any discussion on this as far as considering combining items 2 through 6, we can have that briefly from the board. If not, would there be a motion to combine our testimony on items 2 through 6? Generally, we'd also have to do that in confines of the general time consideration. So would there be somebody who would want to make that motion?
I move that we combine items 2 through 6.
All right, is there a second?
I'll second.
Okay. Motion from Marla, second from Cindy, and we'll just go ahead and go through the roll call again, Tyler.
Lynn Carlson.
Aye.
Dave Gare.
Aye.
Justin Gross.
Aye.
Marlis Jones.
Aye.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
And Mel Pins.
Aye.
Motion carries
Okay,
7-0.
all right. Great. Thank you, Tyler. Okay, so what we will do here, since I think it's my understanding from what Sue-Ann said that the facts of each case are generally the same. This is related to an appeal of the, I think, implementation or interpretation of the zoning ordinance. So we'll go ahead and let Sue-Ann kick us off.
So just in order to get started, I'm going to ask Bert to go through and show us the site map for each site and comment card to begin with. So the first site would be 1922 Ingersoll. That's the map of the parcel. And then here are the comment cards from the Sherman Hill Association, Midas, another comment card. The next site would be the 2742 East University. Here's the site map of the location of that outdoor advertising sign. And your comment card.
Sue-Ann, the top comment card, I couldn't tell if that was in favor or not from Greg. What does that say?
Nice update.
Okay, so that would
Upgrade of
be,
signage.
so that would be in favor, I'm assuming?
I'm assuming, yes.
Okay, thank you.
And then 4337 Park Avenue. Comment card. Did you have a site map for that one, Bert?
Yeah, I was going to show that.
Okay. Yep. So that's location of the one on Park Avenue, George Flagg Parkway. And then we have,
the end item. This is Eric Lendy.
yes,
That's also the same property as one of the other items.
correct. They're independent of each other.
Yeah.
Then we have 3519 Hubble. Comment card. The last one is 215 University.
Okay.
And then we did have a comment from the Merle Hay Neighborhood Association. So while you read that, I'm going to get started on the presentation. To start with, I don't believe the Board of Adjustment has jurisdiction to hear this appeal. The appeal has already been heard by the Building and Fire Board of Appeals and has been decided by them. They heard the issues being raised by Lamar and issued a determination that the permits that were submitted under Chapter 26 were not complete submittals, and this board has no jurisdiction of any of the provisions of Chapter 26. I believe the relevant and undisputed facts before you, although Lamar could have a different opinion, are that on November 15th of 2019 and December 5th of 2019, Lamar submitted a request for evaluation of conversion credits. The request was in the form of building permits that gave the location of the boards they wanted to convert from static to digital. They did not submit, as part of that request for review, the form that we had developed to say from where the conversion credits were earned and where they were to be used. This was necessary to determine which signs were removed under which code and where the conversion credits would be allowed under the old Chapter 134. We had to determine where the credits were allowed to be used and on anywhere in the city or on a specific street. I did not get that information from Lamar, so I had to take it upon myself to do the research to find out where those conversion credits could be used and where they were approved for the locations that they wished to convert the billboard. On December 13th, after reviewing and finishing that review, I did tell Lamar that the permits would be processed. Processed is the the thing that we were doing at that point. So I asked the zoning inspector to go ahead and issue the building permit. She correctly saw that the engineering and the special testing agreement forms were not attached to the building permit. The building permit was therefore incomplete, and she could not issue the permit. Those permits have never been issued. She requested the forms. They were not submitted. Around January 10th or 11th, I checked to see if the permits were issued. I was told that they were not and could not be issued until the engineering and special testing agreement forms were submitted. I checked the transitional provisions of the new code and determined that the permits were incomplete, and the use of conversion credits that they had needed to be used under the new code. Exhibit 1 are the transitional provisions in the new code adopted December 16th of 2019. Provides that, in part, that any building, development, or structure for which a building permit was issued or a complete building permit application had been accepted for processing before its effective date specified in Chapter 134-1.3 of this article may be completed in conformance with the issued building permit and other applicable permits and conditions, even if such building and development or structure does not comply with the provisions of the new zoning ordinance. The permits were not issued. They were not completely given to us. Therefore, they were told that the permits would not be issued. That was in exhibit number 2, is the letter to Lamar on January 13th saying that we were denying the permits because the forms were not submitted and it was not a complete submittal. But they were also informed that they could use the conversion credits under the new code. They were given an appeal rights, and when Mr. Reasoner came in to file the appeal, he was told that the proper appeal was to the Building and Fire Appeals Board. He filed an appeal to go to that board, and a hearing was held. That hearing was held under the relevant sections of Chapter 26, which is exhibit number 3 that spells out the appeal rights. We had the hearing. Exhibit 4 is the decision and order of the Building Fire Appeals Board. The board found that the building permits were not complete submittals under Chapter 26 and upheld the denial. In part, they wrote, the appeal of the determination of denial for lack of completeness of sign permit applications for signs at 2742 East University, 1922 Ingersoll, 4400 East 14th Street, 3519 Hubble, and 4337 Park Avenue is denied. So since the Building and Fire Board found the application were not complete, there is no proper appeal before this board. The use of the conversion credits were not denied. They were approved, but they didn't have a complete submittal for the building permit, so it couldn't be processed under the old code. And this board has no authority to determine that the building permits were incorrectly denied because that's under Chapter 26. The only issues you can decide are the Chapter 134 issues. So there really is no issue before you under Chapter 134. They can submit complete applications for building permits and have digital signs put up on the corridors currently identified in Chapter 134. So I'm going to briefly go through their written submission to the Board of Adjustment very quickly by paragraph. Paragraph 1 is the introduction to their submission. Paragraph 2, the appeal arises out of the city's denial of the applications to convert static advertising sign to digital. That's been decided by the Building and Fire Appeal. Converting signs from that's paragraph 3 has already been discussed and decided by the Building and Fire Appeals Board. So is number 4. All of these issues have already been decided. I did have, in paragraph 5, they talked that I explained to City Council the water's applications were accepted and they were approved. The applications for the conversion credits were accepted and the use of the conversion credits was approved. In number 6, they're claiming that I performed a very thorough review and there was no way to deny the application. That is true. if the building permits would have been submitted in complete form before the December 16th deadline, we would have issued those permits. Again, that paragraph 7 is not correctly raised in front of this board. Number 8 is irrelevant to the discussion. I was getting pressure from City Council, but that wasn't the reason to deny the application. The applications for the building permits were denied due to incomplete submittal. I accept paragraph 9, they talk about applications again. What we're reviewing before that was the applications on where they could use the conversion credit. They talk about number 26 in paragraph 10, again, not before this board. This board cannot discuss or decide anything under chapter 26. Again, that's the same with paragraph 11. We've already discussed, they discussed in paragraph 12 the transitional provisions. We've already talked about that. Paragraph 13, yes, that is when the ordinance came into effect. What's before us is not germane to chapter 134. It's whether or not the permits were issued, and that's under chapter 26. They were denied for incomplete submittal. Again, paragraph 15, they talk about chapter 26. That can't be raised before this board. The historic practices in chapter 17 and 16 and 17 and paragraphs 16 and 17 were raised before the Building and Fire Appeals Board. It cannot be raised in front of this board. Same with paragraph 18. Paragraph 19 is not properly before this board on the Court Avenue sign. Chapter 20 is the correct statement of the zoning ordinance that existed prior to December 16th. The rest are emails between myself and other people, not properly before this board, and I will not go through each and every one of those emails. Again, there is no appeal properly before this board, and I believe that the appeal should be denied.
Okay. All right. Do we have any questions from the board for Ms. Donovan?
I have a question. This is Lynn Carlson.
Go ahead.
Okay, so if this can't be heard by this board, why are we hearing this?
They made an application to come to the board. We have an obligation as staff is to put it on the agenda and then make the arguments. The board has no jurisdiction to hear it. We can't summarily decide that as staff.
Okay.
Right.
This is legal counsel, Ms. Carlson. I was going to confirm the same thing. When an application comes in, its merits or how it should be decided, even the fact that it has been submitted, as long as it's a proper submittal, then it is placed on your agenda and a determination is made at that point. We have to then provide evidence as to what should be done with it. In this case, it is more of a jurisdictional issue than a hearing on the merits of whether the signs are good, bad, or otherwise.
Okay. All right.
Thank you.
Any other questions? Suann, I've got a very brief, kind of two questions, one into the other here. If a permit application was submitted, in essence, the city said it was an incomplete submittal. If the submittal was complete and the conversion credits were applied and the locations were clearly noted, that would have been reviewed under the old zoning ordinance, if I'm correct, and potentially, generally speaking, there may have been an opportunity for some, if not all of these, to have been considered for conversion under a normal permit process. Is that correct?
Correct. If they would have filled out the application for the building permit with all the information that was required and submitted the supporting documents,
Right.
that would have, once we decided that the conversion credits could be applied at the locations that they chose to have them, then we could have issued those permits under the old code.
Got it. And Sven, you mentioned that some of the concerns you had is there were some engineering studies related to the design and construction of these that were not submitted, and a lot of that is the jurisdiction under the building and fire code. Is that correct?
The permit application, the sufficiency and completeness of the application are all decided under Chapter 26, because that's what the permits are submitted under.
Right.
And are the jurisdiction of the Building and Fire Appeals Board, which is where they appealed and got their decision.
Okay, so if I try to give maybe a general analogy or comparison, if you will, to something the board is familiar with quite often, if we had somebody that wanted to build a garage too close to the property line, there are things under the Board of Adjustment we might be considered for its location, such as setbacks or height, but we never have the authority to override things required in building or fire code for that garage, such as how the footings are designed or what materials the structural components are made of. Is that correct?
Correct. You could give setback relief to a garage, making it closer to the property line, but you couldn't tell them they didn't have to fire protect as required under the building code.
Okay. All right. Good. Okay. Well, thank you for that clarification. Okay. Would there be any other questions for Sue Ann? We'll just do going once, going twice.
Sue Ann, yeah. This is Justin Gross.
Go ahead.
Sue Ann, just a couple questions. After the Building and Fire Code Board of Appeals denied their application, could they have then appealed to district court?
They have appealed to district court.
Okay, so they've done that. Okay.
Correct.
That's my first question. The second is, nothing in this denial would keep them from reapplying now under Chapter 134.
Correct.
Okay, thank you.
The locations would be different because the code changed as to where conversion credits can be used, but they certainly can use those as the new code dictates.
Okay. Mm-hmm. Thank you.
Mm-hmm. Okay, if there are no other questions, then we'll go ahead and turn this over to the applicant. And generally speaking, they've got up to 10 minutes to address the board. I can grant a little authority there to make sure you've got a relative equal time to what staff presented on there. So Will, I think we can go ahead and turn it over to you.
Thank you. Is everybody able to hear me?
Yes, sir.
Okay. Again, I'm Will Reasoner. I'm with the Dickinson Law Firm. My business address is 699 Walnut Street, Suite 1600 in Des Moines. Zip code is 50309. First of all, I guess I would request some additional time. Almost wholly, the city's argument is a lack of jurisdiction issue, so I need to address why this board absolutely does have jurisdiction to decide these combined appeals. And then I guess I would like a little bit of time to actually discuss why the board should grant my appeal. I don't think I need too much time, but in terms of jurisdiction, Ms. Donovan, just in her explanation of why she believes there's no jurisdiction, she clarified why there absolutely is jurisdiction. Ms. Donovan stated that when she was looking at these permits, she looked to Chapter 134, these transitional provisions in the new zoning code. And after looking at Chapter 134, she then decided that those new zoning provisions were not applicable. and therefore denied the building permit. So it's true that there's certain dual tracks here where there's a need to follow the building code, but the whole reason that these permits were denied was because of Ms. Donovan's application and interpretation of Chapter 134, which is the zoning code. And this appeal wholly is focused on the unlawful interpretation and incorrect application of Chapter 134 by the city of Des Moines. So I guess another issue here that I guess I just want to make sure that I raise for the record, Ms. Donovan took some time going through essentially community comments about these appeals. Again, this appeal arises from the city's unlawful rejection of applications, after applying Chapter 134. This is not a conditional use permit application. This is not a request for a variance. And so I believe that any community comments regarding this should be disregarded. This appeal should be wholly focused on the analysis of the code chapter and not any consideration of neighborhood desires. I guess before I move on to the meat of this, I'd be happy to address any questions about jurisdiction specifically, if there are any.
I guess, Will, what I would say, I'd like you to make your presentation as clearly as possible to hit all your distinct points, and then we'll ask you any questions if we've got them.
Okay. Prior to today's hearing, I submitted 3 documents to the city, and they have been designated as Exhibits A, Exhibits B, and Exhibit C. And I believe they are uploaded and looks like they are appearing on the screen. So Exhibits A, B, and C are all written submissions that should be considered in full by each member of the board before they make their determination on today's appeals. Exhibit A is a declaration of Jason Pomrenke. Mr. Pomrenke is an employee of Lamar, and his declaration essentially goes through the city's prior practice and how it handled these sign permit applications, and then it briefly discusses the facts that happened here in this case. I don't think that any of the facts in this declaration are all too controversial. Exhibit B is a slightly modified copy of the presentation that was submitted to the Fire Board of Appeals, the February hearing that Ms. Donovan referenced several times. I believe it's also proper for those documents to be submitted and reviewed by this board. And I guess a few comments related to Exhibit B. The Fire Board of Appeals, it's clear in their decision that they did not deny the appeal on the basis of Chapter 26. Looking at the minutes and the recording of that hearing, it's absolutely clear that that board incorrectly attempted to interpret and apply Chapter 134, specifically these transitional provisions, and they denied it on the basis of their belief that Lamar did not fall within application of Chapter 134, the transitional provisions. Now, Exhibit C absolutely is vital information for members of this board to consider. I would disagree with Ms. Donovan that any of the paragraphs here are not properly before the Zoning Board of Adjustment. Each fact, each email here is pertinent to explaining why the city did what it did. Now, on December 12th, 2019, Ms. Donovan sent an email to Lamar stating, "I will have staff process the permit." Now, if we look at section 134-1.11.1a. So this is the transitional provision. It essentially says that permits accepted for processing are considered under the prior zoning ordinance. So what we've got here is a statute, an ordinance, saying that any permits that are accepted for processing are considered under the prior zoning ordinance. And on December 12th, we have Ms. Donovan with the city confirming in writing that she will have staff process the permits. So just based on that email alone, it's clear that Lamar submitted these applications prior to any sort of new zoning ordinance taking effect, and that under the transitional provisions of the new zoning code, all of those permits should have been considered under the prior zoning code. And I believe you just heard Ms. Donovan explain that if that was the case, these permits would have been granted. Now, let's fast forward to December 30th, which is after the new zoning ordinance is in effect. Ms. Donovan, in emailing Councilmember Josh Mandelbaum, explained that the permits were pulled under the old code. There was no way to prevent them from the conversions. Councilmember Mandelbaum obviously did not like this answer. He tried to find ways to prevent Lamar from using the permits that Ms. Donovan had just said there was no way to prevent Lamar from obtaining. In response, Ms. Donovan stated on January 2nd, 2020, if there were any shortcomings in the application, we would not have issued them. Knowing these are controversial, I took extra time and did a very comprehensive review. Since they were issued under the old code and there's nothing to prevent the use of the conversion credits, then it's clear that there was external pressure that was improperly applied by the city council on Ms. Donovan's work as a zoning enforcement officer. And it's clear that the city then fabricated a reason for denial. The city decided to use the new zoning ordinance as a sword to cut off the rights to the permit. The city now claims that the engineering information had to be submitted by December 15th. Well, let's look back at the request for this information. Again, Ms. Donovan stated, I will have staff process the permits on December 12th. The next day, a Friday, December 13th at 10:07 a.m. is when city staff first requested any information from Lamar. In that email requesting the information, there was absolutely no reference to any sort of December 15th deadline. In fact, December 15th was a Sunday. So what the city would have you believe at this point is that after the city requested information at 10:07 a.m. on a Friday, that Lamar was expected to submit all that information within the next few hours. Ms. Donovan said it herself. She took extra time. She did a very comprehensive review. There was no way to deny the permits. But after substantial improper pressure from the city council, the city ignored its own ordinances, made up arbitrary deadlines retroactively, and acted illegally in denying the permits. And again, that illegal action was based wholly on a misinterpretation, misapplication of the transitional provisions, Chapter 134-1.11. And again, I would request that before any sort of decision is made that these documents in the written submission, which includes snippets of emails and then at the end full copies of the emails, I would request that those be specifically reviewed by each member, and that in any decision that those emails and these written submissions be specifically referenced in the findings of fact.
Mm-hmm. Okay. All right. Mr. Reasoner, do you have any more testimony you'd like to present, or would you like to see if there's any questions from the board?
I'd be happy to answer questions from the board.
Okay. Board members, do you have any questions for Will?
This is Lynn Carlson. I'm unable to read these emails on the screen. It's still a little bit small. I don't know if we can go over those and make them a little bit larger. So that's perfect. If we can go through all those, that'd be great.
And ma'am, I'm sorry I did not catch your name, but these documents have been emailed to the city, and I'm sure that full PDFs could be circulated to each member.
If we can read them on the screen like this is fine. I just need to take more time and be able to read it.
Okay. Whoever's controlling the screen, then I'd request that you start at page 4 on the written submission and go through each page slowly so that board members are able to read these.
Yes, this is Bert Drost. If you would, I'm controlling the screen, so if you'd like to tell me when you're ready to move on, I'd be happy to do so.
Yes, this is Judy Parks Cruz, and I was just going to recommend that same process as well. Board members, if you would indicate to staff when you have completed reviewing it so that he will know affirmatively to move on.
Yeah, I'm fine with this page.
Anyone else need it left longer? Okay, hearing none, go on.
Okay. You go on. Okay. I'm fine. Okay. Okay. Thank you. Okay, thank you. Thank you.
And I'd like to point out on this email, Ms. Donovan earlier stated that, you know, in January when she checked in on these permits, that all of a sudden she realized that there were not engineering reports. Well, if you look at this email, that is contradicted. She knew that they were waiting on engineering reports, and then she went on to say if there were any shortcomings in the applications, we would not have issued them.
So were engineering reports required at that time?
No, and that's an issue under Chapter 26. Chapter 26, and I've included these ordinances for you. Chapter 26 states that when required, the plan shall be submitted, and then it goes on to say the plan shall be submitted when required by the Community Development Department. And again, here the permits or the applications, excuse me, were accepted for processing. And then one day later, a Friday morning, is when city staff required the information to be submitted, requested that information. So that under Chapter 26-803B is when that information was triggered. And then it goes on to say essentially there's 180 days to get that information in. That's under Chapter 26-138. So yes, information was required, but it's only required when requested by the Community Development Department, which occurred on December 13th, a Friday at 10:07 a.m.
Okay, thank you. You can continue on with the reading. Okay. 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 Thank you.
At this point, council, members of the board, these emails begin to repeat in order to support my argument that I make, but I believe you reviewed all the emails.
Yeah, I think I've read a lot of the pertinent stuff, so thank you.
Okay.
I'm
Okay,
fine.
do we have other questions for Will? Will, I'm going to throw a question at you here. So Lamar applied on November 15th of 2019 for these billboard permits. Is that correct?
For the most part, I believe there was another application on December 2nd or 3rd.
Okay.
But I guess I think it's undisputed they were all submitted before the zoning change, and they were all referenced in the email that said they were accepted for processing.
Okay, all right. And as far as your involvement with advising your client, were you involved with assisting them at the time that they did submit these permit requests?
I'm not at liberty to go ahead and waive any attorney-client privilege, and I believe that the privilege extends to whether or not I was involved.
Okay.
I'll let Ms. Parks address that, I guess, if she believes that I should disclose that.
No, I think at this point, although it might be something you're curious about, attorney-client privilege is something that we take pretty seriously, and if it has not been waived, then we don't get that information.
Yeah, that's fine. Well, I'll give you a little of my thought here. Not trying to wrap anybody up in anything, but if I was a company that more than likely knew that the zoning ordinance was going to change on December 15th, and I applied less than or about 30 days in front of that expiration date, and maybe, as you just noted, some came in a week or two later, less than 2 weeks or 10 days before this was to expire, I would certainly try to make sure that I was as complete and thorough as possible, and I would have asked upon that submission within, let's say, 3 or 4 business days, hey, how is this looking? Did anybody inquire with the city on the status of their permit review before Sue Ann contacted you on December 15th?
Yes. They, I believe it was Jason Pomrick, he sent emails asking for status updates. Additionally, it seemed like your question was implying why wouldn't Lamar have had this done and accepted for processing before the December 15th deadline? I guess the answer is they did submit all the applications and they were accepted for processing.
Okay.
Lamar, as a business, was aware of the zoning change coming up, and they followed Chapter 134, 1.11, and made sure that the applications were submitted. Chapter 26 allows the Community Development Department to request additional information. That additional information can cost Lamar thousands of dollars. And until Lamar receives the preliminary approval where it begins being accepted for processing, it does not make business sense for Lamar to expend thousands of dollars on a report that the city might not even request.
Okay.
And that is contained in the declaration of Jason Pomrecki, the factual support for that.
Right. And I would generally understand that, Will, and I don't claim to be an engineer, and I'm not on the building department, but if somebody wanted to build a billboard, I would think they're going to have some engineering studies on soils and stability and things of that nature. And it wouldn't be unreasonable for the city to require that, or for somebody with their past experience to anticipate that might be important.
Well, first of all, these are conversions. These are not building new signs.
Okay.
And secondly, I mean, the code is pretty clear that it's when required, and I guess Lamar could have anticipated it. But the issue here is not the reasonableness of Lamar's actions. That the issue before this board is whether the city accepted these applications for processing before December 15th, and it's clear that they did.
Okay. And Will, is your contention if they accepted them for processing, even if to a degree, let's say they were incomplete or more information is needed under even some other chapter, it's your contention that by accepting them for processing, which I would call further review, means that preserves your rights under the old zoning ordinance for final approval under any zoning requirements in place under that old ordinance. Is that correct?
Yes, Chapter 134-1.11.1 sub A. Any building, development, or structure for which a building permit was issued or a complete building permit application had been accepted for processing before the effective date, which is December 15th, may be completed in conformance with the issued building permit and other applicable permits, blah, 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 under the old code. So, yes, the text of the new zoning ordinance is clear that it is accepted for processing is the, I guess it is the transaction that you're looking for. And it's clear that the city accepted the permits, the applications for processing.
Okay. All right. So from either your argument or what you believe the zoning ordinance says, it needs to be an application. If it is not 100% complete, or maybe if some more information is requested or even required later, it's your contention that preserves your right under that old Chapter 134.
Yes, I believe the text of the ordinance speaks for itself, that if an application is accepted for processing. Yep.
Okay. All right. I've got you. Okay. Any other questions for Will? Okay. Seeing none, or hearing none, I should say, what we'll go ahead now and do, Will, is we'll take testimony from any other interested parties, and then we will come back to staff if we have any questions, and then you get a closing rebuttal. Sound okay?
Well, actually, I guess for the record, I would lodge an objection to consideration of any additional testimony. As I stated earlier, I don't believe any other parties would have standing to discuss this. This is an outright appeal. So at this point, the board is, they're looking in the appellate review area. There's no consideration of any community comments or any other party should be considered. It would be irrelevant. And I think any consideration of any other comments would be grounds for reversal at the district court level. So I'd just like to lodge that objection.
Before I make any comments of my own on that, I appreciate your comments. Judy, is there anything that you would want to add in regard to Will's statement?
What I would advise you, board members, is matters of admissibility and relevance are for you to decide. He has indicated what his objection is. You would sort out whether there is any weight to be given the information which is presented, but this is a public hearing, and this is the only opportunity for people who are citizens and have been given notice to make whatever comments they want. I don't know that they will speak to jurisdiction or to the matters that are most germane and being argued here, but we are under the obligation to allow them to speak because this is the only chance they get to. And then you decide whether any weight is to be given it, if it probably will not have anything to do with what is being argued here, but you need to allow it to be heard.
Yeah. I'd say, Judy, that's very well put. As a long-term member of this board and an officer of this board, you know, as Will stated, he felt there was jurisdiction for an appeal to come to this board. So therefore, as such, the board does have an obligation to hear people who would be concerned either in support potentially or in opposition to the appeal, which, as I always say in the preamble, any comments or testimony has to be related to the nature of the appeal itself. So if we do have people that want to get into, I just don't like billboards, or I love billboards and they're wonderful, that would not be something that the board would take into consideration. So if there's anybody here in support or opposition, it needs to be germane to what has been discussed, frankly, by both parties so far, which is either the relevance and jurisdiction of either Chapter 26, 134, or how complete or incomplete the applicant's process was, and how complete or incomplete the city's review was. So I think what I'm going to do as chair at this time, I'm going to go ahead and allow anyone that wishes to support the applicant's request or their appeal, which would be Lamar, to speak first. They would have up to 5 minutes, and I'm not going to vary on that. So is there anybody present by phone or by Zoom that wishes to speak in support of the applicant's request? On the phone, hit star and then the number 9, or by Zoom, hit the raise hand function. And I'll look for staff to help me with that, or anybody that wishes to be acknowledged.
Mr. Chair, this is Eric Lendy. Christopher Morse is the first one that raised their hand.
Okay, all right. So Christopher, I'll need you to state your complete name and address. You've got up to 5 minutes then to address the board.
I'd be happy to do that. I hope you can hear me. I'd be happy to do that at the appropriate time. I understand you're looking for individuals to speak in support of. I am not speaking in support of.
Then at this time, it was not appropriate for you to raise your hand or hit star 9 on your phone. So I'm going to use you as an example. So is there anybody that wishes to speak in support of the applicant's request? We do that first. All right, city staff, see anybody else? If none, is there anybody that wishes to speak in opposition to the applicant's request? So now would be your time to raise your hand, Christopher.
Yes, sir.
All right. We'll go ahead and acknowledge you. Go ahead.
Christopher Robin Morse, 3517 52nd Street, speaking on behalf of the Merle-Hayne Neighborhood Association, who did register an email that you had a chance to view earlier. In regards to what's germane to this conversation and how it's evolved, I will forego any conversations pro or against billboards in general. However, I do think that there's an appropriate context that this board needs to be provided in case they were not aware of it. In paragraph 3 of our letter, we acknowledge that several years ago when Lamar acquired billboards in this market from Clear Channel Outdoor, they soon began removing and replacing sign faces, which we believe violated city regulation at that time, on legal non-conforming signs. We believe that Lamar should have lost their grandfather rights and should have to remove the billboards that were altered. Unfortunately, city code enforcement and legal staff have not pursued removal. This is another reason that we believe Lamar's current sign appeals should be denied. That paragraph in reference to the conversation that's taken place today is important because it illustrates the desire for Lamar Advertising to have their cake and eat it too. There have been numerous instances, and perhaps maybe city staff could comment on these, and maybe they're not germane, but there's been numerous instances where Lamar has flagrantly disregarded city code, the input of the neighborhoods in which they have their services available, and I think that should be taken into consideration. Lamar Outdoor Advertising of Iowa has demonstrated time and time again they do not desire to be a good neighbor in the city of Des Moines, and they want to call out the city's errors when it benefits them, but skirt the city code when it benefits them as well. They shouldn't be allowed to have it both ways, and I encourage the board to deny their application for appeal. Thank you for your time.
Okay, all right. Thank you, Christopher.
Can I ask a question of Christopher?
Please do.
This is Lynn Carlson. What do you mean by a signed face that they removed?
There was numerous billboards in the Merle Hay corridor. My understanding, this is before my time with the Merle Hay Neighborhood Association, so I am going off of institutional knowledge, if you will. But there were numerous billboards that they converted from static to digital, that they should not have been able to do so under the city code. And in fact, it's my understanding that they made these transitions over the weekend to prevent any interruption by city code inspection.
Okay, thank you for explaining that term. I didn't understand it. Thank you.
Thank you for the opportunity to answer your question.
Okay, is there anybody else that wishes to speak in opposition? Okay, seeing none, are there any speakers that wish to speak with any general comments, perhaps neutral? Okay, unless staff notes anything, I don't see anybody there.
This is Bert Drost. I believe Andrea DeVore had mentioned she might be interested in speaking.
Okay.
Maybe she just wanted to listen today.
Okay. Is she still a participant either by phone or by Zoom up? Okay.
This is Andrea DeVore. After listening to the appeal, I think my issues are not pertinent to the actual subject at hand.
Okay. All right. Can we just have your address for the record, Andrea?
Yep, it is 1922 Ingersoll Avenue.
Okay. Thank you very much. Okay. All right. So at this time, I believe the zoning enforcement officer has the opportunity to make a statement if they so choose to.
I sent Bert a document I would like to have us look at. This goes to the question of whether Lamar was notified that they needed to have engineering and a complete submittal before the permit would be looked at or issued. Part of the permit says structural review must be approved prior to issuance of the permit. They signed that. They know that they're supposed to have those permits, those documents in. It's been part of the permitting application and processing for years since they started doing conversion credit. So that was not a surprise for them. They were notified that the permit wasn't accepted the day after I said process it. They were notified it was incomplete and wouldn't be processed.
What date was that, Sue Ann?
That was December 14th, I believe.
Okay.
So the Building and Fire Board of Appeals made a determination that the permits were not submitted in an acceptable format, that they didn't have the supporting documents. So when you look at the transitional provision, a complete building permit application had been accepted for processing. That wasn't a complete building application. I was not aware that the engineering and the other documents were not with that permit. Sometimes Clear Channel submits them with the application. Sometimes we have to wait for them to get them to us months later. So it's not a matter of they didn't know and that they were operating without that information. They had the information. It's on the permit. It was not a complete building permit application. It does not comply with Chapter 26. Therefore, it cannot be submitted under the transitional provision. That it probably would have, if they would have submitted it until it came to my knowledge they didn't have those in, that zoning staff probably would have issued those in error, and then we would have dealt with it and lived with it. But in this case, they didn't have it submitted. They knew they had to submit them. They signed off saying on the permit that they They knew that that requirement was in there. So to come back later and say we didn't know or we weren't asked for those is not the truth, because they were asked for them on the permit application that they filled out. So it doesn't comply with the provisional credit, the provisional ordinance, and the board and the other board already found it didn't comply with the provisional ordinance. They didn't have a complete submittal. This board can't override another board's determination on a complete submittal question. I did not misinterpret that ordinance. That ordinance is quite clear, and it has been upheld. My determination has been upheld by another board that has the purview over that question. Therefore, this board can't override that.
Okay. Joanne, a question I've got for you. So what you're saying, it appears we got some semantics here. A complete application would submit all the required material. Is that correct?
Correct.
And what you're saying
like
is,
if you're going to build a three-story high-rise, and you came in with a conceptual plan, but you didn't have your plans on how you're going to construct it, we wouldn't issue a permit for that.
Right.
Because we don't know how you're going to construct it safely.
Right.
It's a building permit just like any other building permit.
Okay.
It would have been looked at and processed by the person who was processing it, and they would have said, oh, wait a second, I can't do this because you don't have building plans in on how you're going to construct that building. It's no different.
Right. Right. So what you're saying here is this was an incomplete application from square one, so therefore it would then not meet the requirements to allow it to be, in essence, grandfathered through.
Correct.
Okay. How long does it normally take?
Can I follow up with that question?
Sure, please do.
Thank you, Mel. Joanne, so Lamar is basically saying that your email determined that it was accepted for processing. And
They're saying.
What is your response to that?
I said it could be processed under the conversion credits, that they had earned the conversion credits, and it would be processed to allow those structures to go under the old code where they were earned. Then I told Holly, the inspector, I said, go ahead and process these for those conversion credits. She looked at it and said, wait a second, they don't have the building, they don't have the structural and the engineers. So she told them, I can't process this, which was exactly the right thing to do. They didn't have a complete submittal.
Right. Yep.
Now, oftentimes Lamar would come to me and say, can I use these conversion credits here? And then we would work, yeah, you can use them here, and then they'd do the permits and bring in the engineers and the testing agreement. But you can't submit, they can't say, here, we submitted this building permit where we knew we had to have these documents, and say that that's a complete permit application, because we have never issued a permit without those documents. We never have. Right. And they know it. Sometimes they've submitted them with the permit and had it all together, and sometimes they've not, and we've had to prod them and ask them, saying we can't issue this so you can get them in. Right. So it's not a fact that they didn't know that. They knew it.
Thank you.
I have two questions. This is Lynn Carlson.
Go ahead.
On the permit application that's on the screen right now, it says in fine print, you just moved it, now I can't read it.
Sorry.
Structural plans required, yes or no. It's not marked.
That's not it. If you look up where it talks about off-premise advertising, it says,
where is that? Okay, I see that.
It's not a yes or no question. It's a structural review must be approved prior to issuance of the sign permit.
Okay, I see that with one. Okay,
not a yes or no.
Okay, I didn't. Trying to print on a form I'm not familiar with. And then can I have Judy's legal determination on whether we have the authority to override what the Building and Fire Board said or not?
The question before them was whether they believed the submittal was complete. They made the determination it was not complete. and they are the ones who have that determination.
So we could determine.
Go ahead.
So we can. I don't know if this is for now or for our discussion part. So could we determine that they had enough information in that they could still submit their engineering plans and be grandfathered in? If they determined it was not complete, they didn't turn it down. They turned down it was not complete.
If I may answer that, if they turn in a complete building application today, we would review it under the new code, and they would have to pick corridors that those conversion credits can be used on. But yes, they can submit it.
Okay, thank you.
Yes, they can, but as to the locations, those locations will be different. So the determination as to whether it's complete or not has already been decided by that board. That is their question to answer. Okay. Let me perhaps go back, and Mr. Reasoner can also explain this. These two appeals came in pretty much simultaneously. That board met before you did. But they have made the determination it was not complete.
Right. Okay. So Ann, a question for you. This transitional provision basically says that, hey, look, by December 15th, you had to have a complete application in. Whether the city agreed with all calculations or thought there were appropriate ladder rungs on a ladder, somebody would have at least had to present complete enough information for what I would call a complete review in order to preserve their rights. Is that correct?
Correct.
Okay. How long does it normally, and I know you get hundreds if not thousands a year, but if you have a permit of this general type or significance, how long does it usually take for staff to conduct even an initial review once you say, hey, we'll put it in the system for processing? How long does that usually take?
For conversion credit, it can take, depending on the information we get from Lamar, which in this case was incomplete, just on the question of conversion credit, it can take 15 days or more. A full submittal can take up to 30 days, and that would be looking at the engineering plans and the site-specific plans and the setbacks. Yeah. But we couldn't review this because we didn't have those plans.
Yeah. Do you also have an obligation? I mean, can somebody submit something and you just mull it over and it takes you 180 days, 6 months, 9 months? Is there a target you've got to get back to people?
If they submit an incomplete permit and we ask them for additional information, it's on them to get it to us. Okay. Once they get it to us, we can review it. But if it takes them 3 months to get us the engineering and the structural calculations, then we're going to wait that long.
Right.
Under the old code, they didn't have a shot clock or an end date. So if they wanted to not submit stuff and wait till whenever they wanted to build after they got an okay on the conversion credits, if they wanted to wait 6 months because they weren't ready to pull the machines in and build the new structure, we didn't care. Didn't matter to us.
Yeah. So under a normal process, the sooner somebody submits, the sooner they get a review and the sooner they get to implement their project. If we weren't looking at transitions between two codes, correct?
Correct.
Okay.
But they knew about the transition between the codes. They were aware of what was happening.
Yes. And the latest date that you had a submittal that was turned in on any one of these was what? Did I hear December 2nd or December 9th?
December 5th, they turned in a permit with an incomplete submittal.
Which would have been 10 calendar days and less business days before the transition period would expire.
Correct.
Okay. All right. Okay. Any other questions for Sue Ann or other city staff? Okay. Seeing none, Mr. Reasoner, you've got. We'll give you 3 to 5 minutes here for rebuttal or closing remarks. You get the last say in this.
Thank you. Can you hear me?
Yes, sir.
happened?
Will, are you still there? We can't hear you.
Yeah, you're fine.
Hello?
Can you hear us?
Yeah, if you're talking, Will, you're not coming through on my end.
Okay, can you hear me now?
Yeah.
Yes.
Okay, I've been booted off twice. Now,
Don't take
I
that
guess
personal.
well, I am lodging an objection. There were multiple times in the last 15 minutes I've been raising my hand to try to lodge an objection for the record and have not been recognized. Now, if this record gets transmitted to district court, because of the format of this meeting, I was unable to lodge objections, and I absolutely do not want this to be construed as me waiving any sort of evidentiary objection. Now, I need to object to the statements that were made by the gentleman representing the Merle-Hay Neighborhood Association. I do have to lodge objections as the testimony is irrelevant and should not be considered. I need to lodge an objection, I guess just the fact that I couldn't even object and that procedural norms were not followed there. Now, there's a few points that, again, I need to object to any sort of statement by the city pertaining to Lamar's prior conduct in submitting information on the prior application.
Yeah.
There's absolutely no testimony here today and no documentation as to the timing of any sort of prior submittals, and so that's insufficient information on which the board is not permitted to make a decision. Okay. Now, Ms. Donovan stated that on December 14th, an email was sent to Lamar essentially stating that the applications could not be processed or that they were incomplete. First of all, December 14th was a Saturday. I believe Ms. Donovan is referencing a December 13th email from Holly Burgess. If you go to Exhibit C, page 16 of Exhibit C, this is the email on December 13th from Ms. Burgess. Nowhere on this email does it state that the application is incomplete. Nowhere in this email does it state that the city cannot process it. All it says is, I am entering the permits into the system and require the following documents. And Lamar has never raised a did not know argument, that Lamar didn't know that it would need to submit certain information to the city. Chapter 26 is clear that Lamar has no obligation to submit that information until it's requested by the city. And so I just needed to touch on those few points. And on the issue of overriding the Fire Board of Appeals, I think that that's not a proper way to look at this. Council, I can't remember exactly how she phrased it, but I think that I generally agree with her that the issue before that board was whether the permit was properly denied under Chapter 26. And in that proceeding, we, Lamar, argued that there was nothing under Chapter 26 that allowed for the rejection, and that any consideration by that board of Chapter 134 was outside the jurisdiction of that board's purview. And I think it's clear that that board looked to Chapter 134 to determine whether the Chapter 26 denial was proper. We have filed a petition for writ of certiorari challenging that board's decision as being outside of the scope of their jurisdiction, because I think that the appeal before you should have occurred first, where you need to decide whether the transitional provisions under Chapter 134 were properly applied, and then it would be an issue for the building appeals board to determine whether the denial was properly made. So I don't think that you're overriding any sort of decision. I think that the order of events in terms of these appeals has made it difficult to try to wrap your head around what exactly we're seeking. But if we distill it down to the issues before this board, we're asking you to rule on the city's analysis and application of Chapter 134. And I will again lodge my position that the other appeals board exceeded their jurisdiction to the extent that they made any sort of ruling that treaded on this board's jurisdiction.
Mm-hmm. Okay. Okay. All right. Well, I appreciate your comments, Mr. Reasoner. So at this time, as I said, you get the last word. So we're going to go ahead and close the public portion, and we'll go to board deliberation. So board members, again, at this time, there's no hand raising by anyone except fellow board members to talk here. I think I do feel that I owe Mr. Reasoner a little bit of a response here. I'm sorry if he was disconnected temporarily from the call, if that so happened. However, the schedule of this public hearing is very clear. The aggrieved party, usually the applicant, or in this case Lamar, they have a specific time period in which they provide their testimony. If others are providing testimony that someone believes is irrelevant or incorrect or improper, they don't have the authority in the middle of that testimony to object to that or to change the schedule of the public hearing and ask for objections to be reviewed continually as the hearing progresses. If we were to do that, then I would think that I would have the authority to either sustain or overrule such objections, and I do not. So therefore, that is why within our preamble and our opening statement, we clearly state when testimony is given, when people will be acknowledged, and I reinforce that double, triple, since we're doing this by Zoom. And we didn't recognize people outside of the parameters and venue as I provided. That is why Mr. Reasoner had, in essence, the last say in this. So that appellant's rebuttal, that gives them a chance, and I think he made his points very clear from his perspective what his concerns were. So it is up to this board then to review the facts, and as the preamble states, to consider those facts that are relevant based on the zoning ordinance and the issue in front of this board. So I'm going to ask my board members to give any statements or discussions that they would like to have, and then thereafter any potential motions here. So I'll open the floor to my colleague.
This is Lynn Carlson. Of course, I've got some opinions here. First thing is, oh gosh, I don't know where to start. The other board determined that the application was not complete, and that's all that they determined. So according to that, whether or not it was not complete, that's fine. I have no problem with that. They didn't deny it. They said it was not complete. I am somewhat concerned with the emails that were going on between the city council members on a way to stop this from happening. I don't so it's good faith of operating within the law. It may not be something we like as far as electronic billboards, but we are not here to say whether we like them or we don't like them, but what is the law. In regards to the Merle Hay issues, in any court of law, prior acts should not be considered unless it's relevant to this particular item, and I think that's the same way. We should be just considering the facts of this case. And my thing I'm looking at is on the email that was written from Holly Burgess on 12/13, she gave no date on when the stuff was due. So according to my thoughts, because the application is open until it's done, as Sue Ann mentioned earlier, sometimes they would take several months to get these reports in because they weren't ready to pull everything yet. Since there was no date given there, I mean, if we were trying to go with the transition at that time, I would have said within 30 days in that letter. There is no time frame in the letter. So I believe that because it was submitted before the change, that he should be allowed to submit those engineering reports, and if those go through, have his permit issued. But those are my thoughts.
Very well spoken. Others?
This is Nathan. I don't know if I'm ready to talk about the case itself, or I'm interested in hearing from other people, and I kind of have a sense of where I'm leaning, but I don't know if I have much to say about it. I will say that I didn't find the
questions from the council members, although I couldn't really read Bill Gray's, but the questions from Council Member Mandelbaum, I didn't find them objectionable at all. It was essentially just asking questions about the legality of something, and I didn't read it as improper or anything further. It wasn't directing anyone to do anything illegal. It wasn't directing them to bend the rules in any way. It was just inquisitive. So that's, I guess, what I've got to say.
Yeah, I can agree because he asked if there's any way to stop it. So
yeah, right. Which I don't think is improper because clearly he doesn't want it, but that's not saying, hey, do something underhanded to stop this. It's just, I think there's an assumption, and frankly, knowing Mr. Mandelbaum, I would assume this of him, an assumption of, taking whatever, legal ways and approaches to stop this is the underlying question, and I think that's totally appropriate.
no, I don't know him, so yeah, that's fine. So okay, thank you.
This is Cindy, and my comment, hi, Mr. Chair, this is Cindy. One of my comments was that in terms of stating a time frame, stating a deadline for submission of requested information, I'm not sure what the protocol that the city follows. What I've heard from folks so far today is that they will say to the applicant, you need to submit XYZ, but the city doesn't generally impose deadlines on them unless it would be for something really specific. So for this, I think they would just say, we need this information and not impose deadlines. Maybe I'm way off on that, but the impression I have is that deadlines generally aren't imposed or, you have to have it to us by a certain date. I don't know that that's city protocol.
Yeah. Okay. Mr. Chair, if I can just give some of my own opinion. This
Please do.
Justin Gross. I read as much as I could here, and it appeared that Lamar is trying to pull the permits under the old code, and the old code, would allow for the conversion credits to be used, and really cannot prevent it, in order so those could be used without being prevented for the type of use. And therefore, I feel like that using the old code, then the building and fire code has the appeal jurisdiction, and they made their decision. And the proper remedy then, after that appeal decision, is to do what Mr. Reasoner is doing, which is go into district court. So the applicant is taking that natural step to do. And so, it also looks like, looking at that application that Sue Ann showed, that it shows that the engineer report is required. And, on the issue of was it accepted for processing, that it kind of depends on the interpretation of that, but it sounds like the following day they let the applicant know that indeed it wasn't accepted for processing and they were required to do these other steps. Yeah. So, that's my 2 cents. Thank you.
Sure. Justin, I think you have some good points there. I would generally concur. I might have a few concerns here. I probably wouldn't submit an application less than 10 calendar days before the end of an old zoning ordinance. But if I did, I would want to make that application as complete as possible. I would ask where it's at in the review. And Chapter 134 states that a complete application has to be submitted. So the concern I've got here is maybe very much as you've also mentioned. I believe this board, as citizens, we come to this with common sense, our own experience as citizens, but I do not believe that we are entirely a court of law where it's up to us to decide if somebody else's set of ordinances, some other appeals board jurisdiction is relevant or not. That's a job for a district court. And that appears to be where a lot of this case might hang on the applicant's side. And from their perspective, if they do say Chapter 134 is where this all should reside, then they should have submitted an application that was complete enough so that it could be reviewed. And frankly, I would want to make sure I had that in plenty of time, because the staff has clearly stated they receive a lot of permits. A lot of their permit review takes time, and unless they're really pushed on that, people sit and wait till the permit's issued. So if I was concerned about a transitional permit or a transitional code of ordinances, and I wanted to make sure that my permit got in, I would submit it early, I would submit it complete, and I would bird dog that sucker. So in my opinion, if the applicant believes that they are aggrieved, for all parties, I think that this could be a district court case for everybody to fully adjudicate this beyond what I feel our duties are, which is the general interpretation of the zoning ordinance. So those are some of my thoughts. But again, we got some other members here, so any thoughts they have, and then any emotions anybody might have, we could consider.
If no one else is going to speak, I would like to make a motion.
Fairly put. Anybody else want to say anything? If not, Marlos has a motion.
I recommend that we move forward to accept the staff recommendation. That is, the staff recommends that we defer this to the other board ruling.
Okay. All right. And do you have any thoughts or reasoning behind that, or are you?
Basically, I totally agree with what Justin and the point that Justin and yourself made.
Okay.
And, that just flows for me.
Okay. All right. So we got a motion by Marlis to accept staff recommendations. Is there a second?
Can you put the staff recommendation up on the
screen,
please?
Good point.
Thank you.
Okay. All right. Okay. All right. So we got a motion by Marlis. I'm going to go ahead and second that. This was an application for a sign permit as required under Chapter 26. So I'm going to second that motion. So all those that would be in favor of the motion as presented, we'll take roll call. Please say aye or nay.
Dave Gare.
Aye.
Justin Gross.
Aye.
Marlis Jones.
Aye.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
Lynn Carlson.
Nay.
And Mel Penns.
Aye.
Motion passes 6-1.
Okay, I appreciate everybody's interest in this on all sides, and certainly my colleagues here for a thorough review. Okay, so that concludes that agenda item.
Actually, those agenda items. So this.
Oh yes, that concludes agenda items 2 through 6.
Thank you.
As those were combined for testimony and motions and decision making.
I may, although this is unusual, we have Mr. Reason has his hand raised. Can we entertain any questions? Do you have questions for clarification or something?
I think as long as it's very brief, I would be willing to entertain that. Will, is there something you want to say?
Very, very briefly, the staff recommendation, as I read it, was that this board lacks jurisdiction to hear the appeal. And as I understood the last vote, was that it was 6-1 that the board lacks jurisdiction. Can we just make it clear for the record that that was the basis of the decision? It was not on any of the merits?
I think that's more than fair, Will, and I will, in essence, kind of re-quote myself. It said in there that the staff's recommendation was that the application was for a sign permit, which was under Chapter 26, and so therefore, yes, this board lacks that jurisdiction to review items under Chapter 26, which included those applications related to that sign permit and the requirements therein. But yes, that's as simple as I can place it.
Thank you.
Okay, so once again, that includes our hearing and the appeals process. I gave that in our preamble, and if anybody has any questions on how that works or is implemented, I'd suggest that they review the municipal code. Okay, that'll move us on then to item number 7. And let's see, Bert, can you throw that up there where I can see the top end of that? Let's see, thank you. Okay. All right, item 7 is a special permit request at 2560 Southeast 14th. So I'll turn it over to staff.
Mr. Chair, members of the board, this is Eric Lundy, Senior City Planner. Item 7 is a request, I believe it's Bodhisattva Meditation Monastery. And they are back to you after a decision that was made back last November with regard to a special permit under the old code, former code, I should say, which allowed special permits for institutions of religious character, and in that case, they were given a phased program, essentially to develop the parking in accordance with the requirements for their use, which was to use the building at the site for their religious assembly function. So that triggered, the need for a certain amount of parking. They had already had a site plan previous to that, and that site plan then was given some phasing, and I'll show you the order at the end of the presentation so you're clear on what the order was on November 20th, 2019, but I'll proceed with what they are asking for first and give you a little orientation to the property. And I'm going to fix this, I think, to make sure we get the proper. Otherwise, some of these graphics aren't going to show completely. So this is the property we're dealing with, East 14th Street, Highway 69 on the right, and there's an entrance off of that to the site, and then there's also an entrance off King Avenue coming from the south, also going into the site. This is the building in question. There's also a residence there as part of it. This is looking down to the north on this lane entering in from King Avenue. And then this is looking the other way down the lane that comes in off Southeast 14th Street from the facility. Then this is looking back towards the other lane that we looked at coming in. Kind of pulling back further to see some of the area to the right, which is also parking. One of the things you'll notice is that there's a sort of it's not unfinished. There's areas that were paved with asphalt over time that have become in such disrepair that gravel was started. They started putting gravel at some point in time over the top of it, so there's areas that have a surface of gravel. But if you actually look really closely, this area had been at one point in time had an asphalt covering, and it's been topped over with an aggregate material. There's some that is a little more in good repair here. I think that's the area of their focus at this point in time. So this is a diagram of showing an additional area that they would now like to improve. The applicant is stating that they have economic hardships that are preventing them from meeting the schedule that was approved by the board in November. And they want to work within what's already paved currently, which you see, and then at some point in the future add additional paved spaces to the east of the building to finish that out. This is the staff report, which you should have received. If you didn't, I'll summarize it here and then get to the recommendation. The 4.8 acre site. This is in. This was also given notices to Indianola Hills neighborhood, which it's in, and then the Pioneer Park neighborhood, which is to the east across Southeast 14th Highway 69. This again is under criteria that were established under the former zoning ordinance and has some general requirements for all special permits. We're not really dealing with building matters here, mostly just site issues. This is the history again. Back in 2013, the special permit was given for a farmer's market. I don't believe that's any longer part of their operation. But then in November of 2019, the board granted special permit to allow a religious assembly with 28 paved spaces. And then additional gravel surface parking for temporary use to be formally paved at certain points in time. There was an area identified as phase 1, and I will get to that sketch too as well. That was supposed to be paved by May of this past May 22nd. They did not reach that benchmark. So then they filed this application in anticipation of probably not meeting the benchmarks in number 3, which are phases 2 and 3 to be completed by November of 2021. And then in the interim, the areas that were in phases 2 and 3 were to be paved with a dustless material until the point in time where it was permanently paved. And then this is the standard language that it could be revoked or brought back for reconsideration if there was they've done this, they've come to the board voluntarily, and this is again being treated under the former ordinance. I'm going to go now down just so you get a clear understanding of what that phasing was to be. one that's labeled. So the initial area that they were going to have paved was to the west or to the south of the building, to the west of the main parking area. So this was the area that was supposed to be finalized by May 22nd of this year. And then phases 2 and 3 were these parking areas that would in the interim have to be covered with a dustless material. Phases 2 and 3 included the drives and these additional spaces. So that's why they were supposed to be done simultaneously. And again, this is the areas in the decision in order. So again, I'm going to show you this sketch. I'm wondering if David has something different he wanted me to show, I need to have him email that so that we can get it put up there for him. I seem to recall that there was another drawing that he had shown how to stripe the existing paving area. Staff essentially is concerned, with perpetuating this again and again under the old ordinance. So one of the things, while it might be reasonable to consider giving them a time extension due to their economic situation, I think there's got to be a point where if they're not delivering on the terms of the special permit, that we really need to start viewing this under the new ordinance, which would actually go through Chapter 135, and then any appeals to those requirements would actually be reviewed by the Plan and Zoning Commission. So right now, staff is recommending, and I'm going to zoom in again here so you can see, that we are recommending approval of the request to amend this for an institution of religious character. We want compliance with a site plan to actually formally document this under the special permit. That will be trigger some requirements under review by Chapter 135. For example, landscaping and plantings that wouldn't be under the purview of the board, but yet we would be able to proceed with a site plan that's actually on record, which there isn't currently one of record that we can go from. Number 2, the existing paving identified as being repaired for 32 on-site parking spaces in accordance with the site sketch shall be completed no later than May 31st of 2021. So that's giving them another full year after the date they were supposed to meet to begin with, to allow them to get that area repaired in good repair and striped properly, so that can be functional for the use of the facility. And we did want to state then that the special permit shall expire if the improvements are not completed by this deadline, and therefore would not be considered for further by the Zoning Board of Adjustment. So if they don't meet that marker or that benchmark, then at that point we would call it not in compliance, and they would need to then submit everything under the current Chapter 135 provision. Number 3 is that same standard language about if there's some kind of pattern of violation. So down the road, if they continue, they do meet the terms of this decision and order, and they show some pattern later on of not following what they had put into place, then that could be brought back. And I should probably check and see if David submitted anything.
Are you still there, Eric?
I'm looking to see if David emailed any a sketch of the 32 space layout.
Okay. And Eric, if that's not handy, I understand staff's recommending approval here. Could you just summarize it the best you possibly can, if that's not easy to find?
Yeah, right now I'm just double checking to make sure it wasn't in the folder.
Okay.
And that he didn't email it. Apparently I don't have an email. He's raising his hand, but he's muted, and I can't unmute him.
And is that because he has his own mute button on? I mean, if it's a procedural thing, I'd be glad to recognize him, but he may have his own mute button on.
Yeah, he may have to unmute himself to talk. He does have his hand raised. So.
Yeah. Sir, I think staff will recognize you, but you may have to take your mute button off your computer.
Okay, it's mute. Can you hear me now?
Yes.
Yeah. Oh, great. This is David Churchill. 20701 Kirkwood Street, Milo, Iowa. I did send a revised sketch to Bert, so it should be in the file somewhere. If not, I'm unavailable. I can't send it again right now. But briefly, based on the additional information and the staff rationale, we would ask for approval from the board, and with the intention of repairing the existing hard surface, and that was identified in the sketch that I sent to staff earlier, meeting the deadline, and if I understand, the one of the conditions is to add planting. If that's required, we would be, the owners are agreeing to do that within that first year period. It's just unfortunate that during the current conditions, they're basically shut down, and it's very difficult for them to do any sort of fundraising or that kind of situation.
Yeah.
So with that being said, we agree to the conditions and look forward to your positive response. If there's any questions, I'd be glad to answer as best I can. Thank you.
Okay, David, I really appreciate your
sketch.
Yeah, I appreciate your conciseness there, but I think we were just trying to have you acknowledge if there was a site sketch. It sounds like we moved into your testimony. Just very briefly, what I'd like to do is go back to Eric. Eric, is there anything you want to summarize with us?
Mr. Chair, so this is a sketch, and the reason it wasn't showing up is because it's a file type that wasn't in the listed file types on the browser, so I had to check all file types, and then showed up as a PDF or a JPEG. I'm sorry. So this is area that's currently hard surfaced, and they're proposing 32 spaces in that area, and you'll notice there's 3 up in this area as well. So in the interim, they seek to repair these surfaces to be serviceable for parking and have it striped with an overlay. And they would agree to have that done before May of 2021, or that's what staff is recommending, that they have that accomplished by then. But we also are seeking the site plan that would show a full build down the road for additional parking to meet their overall requirement. They're somewhat deficient. So right now we do want to see a site plan to show this repair and the striping, basically a more formalized version of this sketch. And then getting that on the books with landscaping, and like I said, some of that's going to be in accordance with Chapter 135 provisions. And then they would then, anything that they would expand over time, they would do as amendment to their site plan, and it really wouldn't come back to the board in the future unless they didn't comply and the zoning officer felt compelled to bring it back under the special permit clause.
Okay. All right.
So does everybody understand where the parking is being laid out then on the existing paved areas? And I can go back to the aerial then too, and then show you.
Yeah. And Eric, what they're proposing to do fits with your staff recommendation for approval. Is that correct?
Yeah, we're recommending that they get that done in that reasonable amount of time. So.
Okay. All right.
Go back here. I wish I could get this to show up all on one page, but it's not that way. So. And understand that if they don't meet that May 31st, 2021 deadline, in the interim, they have the option to file under the new code. If they don't meet that, then everything, this permit expires and they're kind of starting from scratch under the new code.
Okay, I've got it. Yep. So we're not going to have a phase 2 and a phase 3 as we did before. It's basically they need to get it done by May 31 of 2021.
Yes, and this is a reduced number of spaces from the previous decision and order. Yeah. So you have to take that into account.
Got it. Okay. All right. What else do you want to add?
So then here's the cards we received, 2 in favor, and then I will show you the consent map. One Anhofer down in the southeast, and then Estrada, which is this LLC over here to the west, in favor. This is their statement that they submitted with their application. And then I have the decision in order if you need to reference that as well.
Okay. All right. What else do we need to cover here, Eric?
That's all I have unless there's questions for staff.
Yeah, board members, anything for Eric?
I have a question, Al.
Go ahead.
What are the consequences if they don't meet this? And based on the current situation, we may not have anything until after the first of the year as far as the vaccine goes. It's going to affect.
Is that, I mean, are you asking staff that, I mean, if the board was to deny this or does not, approve something in differently, then they would be facing, occupation.
If the parking is paved per the drawing they're going to submit in the timeline, what's the consequence?
Yeah, so they would lose their occupancy permit to operate at that facility if they don't get the paving installed by the end of May of next year, if we're inclined to approve the staff recommendation. Is that right, Eric?
That's correct. Yeah, they would be jeopardizing their occupancy of the premise for not complying with parking and requirements.
Right. Yeah, unless we wanted to grant them a variance from those parking requirements. I'm not saying we are, but yeah.
Well, I'm not trying to be argumentative. I'm just saying we've been down this road once, and here we are.
Yes.
I think we're going right down the road again, and I just want to. I guess I'd like to understand, what are we prepared to do if they don't meet the requirement?
That's a very good point. And
because I'm going to suggest that we put that in the motion that we make if we're, and I'm not saying I'm for or against, but there's too much that we just go down the road and then we do it. It's a do-over and a do-over. Let's start stepping up here if we're in fact prepared to do that.
Right. I think in the staff report, and Eric, you can help me with this, if they would not comply with your recommendation to approve this amended number of parking spaces and the timeline, they don't comply with it, then if they want any new consideration, we have to do that under the new zoning ordinance to begin with, which should be a lot more painful. Is that correct? As simple as possible.
Yeah. They really, this is kind of their last opportunity with the board, unless we bring it back for some pattern of violation. If they don't get something going to meet your deadline, then anything further we would accept under the new code. So.
Yep.
And then I guess what I would only say is then I would expect that you're prepared then to enforce that and not have another duel.
Yeah, that'll be Stuan's vote.
Your comment was their occupancy permit would be potentially revoked.
It would be in jeopardy, yes. That would be one of the measures that could be taken, yes.
All right. That's all I have, thanks.
This is David.
All right, let's hold on here, David. We got a little off track on our hearing process. So, Eric, are you done with your presentation?
Yes, I was just answering questions. So.
All right. Do we have any other questions for Eric? Okay, seeing none, David, I'm going to give you 10 minutes. You can present your case. Again, we're going to need your name and address for the record, and then tell us your reasoning for your appeal, and if you agree with the staff recommendation.
This is David. Can you hear me?
Go ahead. Yes.
Okay. Yes, we agree with the staff recommendations. I'm sorry. David Churchill, 20701 Kirkwood Street, Milo, Iowa, 50166. We agree with the staff recommendations. I also want to state that the owners feel that they can meet the requirements of the sketch we provided within the time period of approximately 1 year. If that should change, then we'll have to deal with that down the road. But that is what I'm authorized to tell you guys. Other than that, we just hope that you'll approve our application and we can move forward as best we can given the times that we're living in now. Thank you.
Yeah.
Okay. And I'll answer any questions.
Great. Yes. Any questions for David?
But I can't hear you.
Any questions for David? Okay. Seeing none, we'll go to the next part of the agenda. Is there anybody that wishes to speak in support of the applicant? All right. If you want to speak in support, just raise your hand through the Zoom app or hit *9 on your phone. Anyone in support? Going once, going twice? Okay, do we have anybody who wishes to speak in opposition to the applicant's request? Same process, raise your hand through the Zoom app in the participant window, or hit *9 on your phone, and you'll be recognized. Anybody to speak in opposition? Going once, going twice. And does anybody have any general comments that has not already spoken that would like to speak with maybe neutral comments? Same sign. Okay, seeing none. Do we need to address zoning enforcement comments? Staff? If not,
Chair, members of the board, this is Sue Ann Donovan. Just want to say yes, if they don't comply, zoning enforcement is ready to go in and do enforcement as necessary.
okay, all right. And you always try to work with people first, but yes, sometimes enforcement is what's needed. Okay, thank you. Do we have any further questions for city staff from the board? Anybody? Okay. The appellant could have a rebuttal, but David, since there have been no comments or any other information presented, anything else you want to say?
No.
Okay, all right, thank you. All right, we'll go to board deliberation. So, members, based on Eric's good presentation and as well as David's comments, any questions you or anything you'd like to discuss as a board, and therein any reasoning for a motion?
Mr. Chair, this is Justin Gross. I would just say that I think the staff recommendation is very compassionate. You know, it takes in consideration what's going on with COVID, and yet it also creates a backstop. So, you know, things will either happen or enforcement will occur, and they'll have a harder time moving forward. So unless there's other comments, I think I'd like to put a motion to move staff recommendation.
Okay, so we've got a motion by Justin. We can certainly consider some other discussion, and therein, perhaps if there'd be a second on that. So anybody else have any other thoughts or a second?
Chair, this is Lynn Carlson. I'll second his motion. I think, again, with COVID and everything, compassion is certainly warranted, so I second that motion.
Okay, we've got a motion and a second, and I think Justin's reasoning is there in accordance with what staff had put out there for their rationale as well. So, would there be we'll take a vote here. We'll be voting on approving staff recommendation. All those in favor, we'll have Tyler take roll call.
Justin Gross.
Aye.
Marlis Jones.
Aye.
Cindy Smith.
Aye.
Nathan Blake.
Aye.
Lynn Carlson.
Aye.
Dave Gare.
You there, Dave? For some reason, Dave, we haven't caught that. Are you on mute?
Sorry. Aye.
And
Okay.
Mel Pins.
Aye.
Motion passes 7-0.
Okay, all right. Thank you, Tyler. And David, we appreciate you tuning in today to represent your client. And we look forward to them getting that amended parking area in next spring at the latest. Okay, that'll bring us to item 8, which is a variance request at 4337 Park Avenue.
Chair, members of the board, Jason Van Essen with the city planning staff. You see the agenda heading ahead of you. This is a variance request for rooftop mechanical equipment screening. The permit and project started under the previous zoning ordinance, so we are reviewing this today under that standard and that criteria. Hopefully you're seeing an aerial identifying the subject property on the north side of Park Avenue at the intersection with George Flagg Parkway.
Yes, sir.
In this aerial, you'll see the footprint of the building that was there at the start of the project. The applicant expanded, renovated the site, and the project's still underway.
Okay.
Photograph of the property looking at it from the kind of the east corner of the side at the driveway. You can see the shorter part of the building or the original part, and then the additions to the side and back. Mechanical equipment on the roof, subject of our discussion today. Photograph of the building looking straight on. In your packet, you received a staff recommendation. We sorted out the standards that apply to this application, provided some analysis and a recommendation. We are recommending denial. The applicant's case or concern that they've brought forward really is twofold. One is changes in grade between the street level and the level of the site, and then also the cost to modify the building to be able to install screening. In looking at the topography that you saw in the photographs, and then, I did a site visit, and I don't think that that's a concern. The site and the sidewalk are within 5 feet of each other. I think you can put in screening material that would adequately screen the equipment. What's not been clear to us as staff is the impact of putting screening on the building with regard to structural reinforcement and costs associated with that. We haven't gotten that information clearly presented to us. Also, not 100% sure what different alternatives the applicant looked at. I believe the applicant's architect is with us today, so I'm hoping that he can focus his presentation on the challenges that they see to providing the screen. I'm just flipping through. This was the submittal from the applicant talking through both the grade and load issues, snow load, or the structural load. I have the site plan available. Let me escape or get out of the full screen mode so I can jump. I won't go into a lot of detail on that. I think I'll go ahead and skip the site plan. This is a diagram that was submitted with the application, just generally showing where some of their pictures were taken, and then where some of the equipment sits. It provided a cross section. We can come back to this if the board feels they need to see it again. Roof diagram showing some of the equipment. The original part of the building is this rectangle here, and you can see that there's the equipment in the middle of that building, but then there's also equipment on the addition part of the building. The response map. I have cards. We did get one letter that came in today that is not recognized or identified on this map. It's just another property owner within the townhouse development. So two of the cards. Couple more cards. Couple more cards. If I'm flipping too fast, just let me know. And then here's the letter that came in today. I'll give you guys a minute to look at that. Let me know if I need to zoom in.
Who is Clayton shot with? Is he representing someone else there?
No, he's one of the, he owns one of those townhomes.
Got it.
There's his address at the bottom.
Okay.
With that, I'm happy to answer your questions. Like I said in my presentation, I think what we really need to hear from is the architect for the project walk us through what challenges they face from a structural and cost standpoint, because that's really kind of the missing bit of information.
Sure. Questions for Jason?
Hey, Jason, this is Dave here. When they submitted their drawings originally, did they show screening? Because that's part of the design requirement.
You know, I don't have, I don't know if it was included as a note on the site plan or if it was something that went to our plans reviewer in their submittal. I do know anecdotally from talking to one of our building plans reviewers that when the project first came forward, the applicant wasn't aware of how many condenser units was going to end up needing to be installed, and as they moved forward into construction, once they brought in the consultant for that, it expanded. So I think this is a case where maybe the information available in the situation was a little bit unknown at the beginning, but I'll let the architect for the project go in a great on that.
Okay. Jason, did this have to go through a complete site plan review?
Yes.
Okay. All right. And could you maybe put up that very nice picture that shows the building, how it looks now from Park Avenue, if possible? Because one question I have, it actually looks like there's a parapet or an upper wall above the roof line on some of the other sides of the building that acts as screening from both the east and maybe north sides.
That's a correct observation. The addition was built with quite a parapet wall, so the only area that needs to be screened is the views from Park Avenue as you look at the site directly from Park Avenue, and then slightly to the east. Like from this perspective right here, which is their easternmost driveway, or their property line.
Gotcha. Okay. All right, thank you. Any other questions for Jason? Okay, we'll go ahead and turn this part of the hearing over to the applicant. We just need your complete name and your address. Business-related address is fine if appropriate. And you've got up to 10 minutes to present your reasoning for your appeal.
Rich, you should be unmuted now.
Okay. We'll start here. This is Bruce Gerlman, 303 Locust, Suite 150, Des Moines, Iowa. I own Clampett Corner, which is the property owner, and I also own Jethro's Barbecue. This has been an exciting project for us here on the south side. It was a difficult site to work with because of the elevation changes. One of the first things we had to do when we started with the site was bring in 90 truckloads of dirt just to raise the elevation. The biggest issue that we have here is that as Park Avenue runs east and west, as you go from west to east, it goes up a hill. And that at the southeast corner of our property line, or southeast corner of our property, that hill is 6 feet higher than our floor level. So when you're over on the southeast corner, you're looking down at the building. We have almost 800 lineal feet of frontage on George Flagg Parkway, and combined with Park Avenue. So we have 800 feet of frontage. All we're talking about is that south 200 feet of frontage. In the new construction, as you look at this picture, you see the parapet wall in the background. All of that is constructed to hide all of the mechanical work. The problem, or the real problem for us, was the existing building. I wanted to save the existing building. I've done historic renovations throughout the city, and that building to me was important to save, and that caused some limitations on what we could do because of the structure. We did, as a part of our submittal to the city and on site plan and on our original submittal, we did raise the parapet on the existing building where it says south side. That is the existing building. We did raise that parapet 3.5 feet. And that is, we were limited because of snow load calculations and structural shortfalls within that existing building. So that's our biggest issue. So my solution and my proposal to the board would be, as you look there, we're limited. We can't put anything up any higher on that part of the building. Would be to paint all of that equipment painted all white, so that it all blends in, and so in that background all you see is white, and then all of that equipment would be painted white. So that's my proposal to the board. I'm gonna have Rich Ayers, who's the architect who designed all of this, speak now on the technical issues of the structure and those issues. The other comment that I would make, you did receive some negative comments from the people who live across the street in those townhomes and apartments. If you look, I think you had 5 negative comments, and they all are living on the second and third and fourth floor of those buildings, so they're looking down on the top of our roof. There's no possible way that we can shield those units from those people across the street that are looking down on the top of my roof. And so with that, if you have any questions for me, I'm happy to take them. Otherwise, Rich Ayers, the architect, is going to speak now.
Okay, and if he's gonna do that, that's part of your 10 minutes to present. So I'll ask him to keep it brief.
Okay, here he is.
This is Rich Ayers, Ayers Design Group, 6876 Harding Street, Indianola, Iowa. The primary issue is the existing building was a convenience store with 13-inch bar joists and no parapet wall at all, so it had no snow load. Anything that we would do within the border or overflat loading onto the structure would create snow drifting. That was causing 17 to 20 pounds of additional snow load, or doubling the snow load capacity of the roof. When we received staff comments, I did submit staff comments here Friday. I did submit drawings from Comet Ditch Engineering showing the requirements to provide additional screening, and that entailed, I'll hold it up and see if you can see it. Do you see that from the monitor?
All I'm seeing is the staff's picture, unless I'm picking up everything.
Okay. Then you don't have our picture. You just have our sound. What it amounts to is we would have to put in new W16 by 21 beams between each of the existing bar joists within the roof. That would be a 32-foot span because this is the dining area and it's all open. Mm-hmm. They weigh 21 pounds a foot, so you're talking about 32 feet times 21. So you have 800-pound joists that would have to be passed through a window, and this is even during initial construction. Passed through a window, lifted in place, and anchored to the existing walls. We would then have to dig underneath the foundation and re-support the foundation for the additional loads. So that is the difficulty to adding a screen wall to the south side or east side of the existing building. By the same token, if we added a screen wall to the addition areas, that creates a snow drifting onto the existing building again. So that's why this corner was left open during initial design. The mechanical equipment that is visible, the first one sits on top of the existing roof and is essentially the same that was there before. It's just a more efficient unit. So it was visible originally and is visible now. The equipment that you see, the ductwork and the exhaust fans in the back, which is 32 feet from the front of the building. So under normal circumstances, the building would screen that equipment. That equipment can't be moved to another location because it has to be directly above the kitchen hood. You cannot put elbows in mechanical equipment for grease hoods. So that's the reason for the equipment being where it is. We did make a change in the style of equipment serving these hoods, which brought them more towards this location, being back behind the existing building. The primary thing is that our eye level is at 6 foot of the ground plus 5 foot person. That puts us at 11 to 12 feet, and the top of the parapet is 14 feet. So we're looking eye to eye with the roof, and it's impossible to screen that. Now you see that straight on as eye to eye. If you go to the next picture, you see what it would look like the other direction.
And then he's asking you to go the other direction.
Yeah.
Back up with your pictures, please.
Okay.
It is photographed. That's okay.
One
and
more?
then there's one more where you see the graph.
I think I only have 2 pictures that I took. I might have some in the information that you submitted.
In the submittal that I provided, the photograph number 6 in the submittal shows what your eye level would see.
Which photo number?
Page 2 photo, or page 4 photo number 6. Okay, this one, yeah, that one there. As you can see, you just barely see it. That is at eye level at 5 foot above finished floor. So typically your street is at the same elevation in the front or lower than your finished floor. So as you can see from this view, under typical sight, you barely see the units. You don't see any of the units that are sitting on the roof behind the building. You see just the one mechanical unit that basically was existing and was replaced. So grade is, the 2 issues is the raising up of the street brings us to an eye level that we can't screen. The second item is that the structure required to have roof screening adds a tremendous amount of difficulty and structure and money, and I mean, to try to bring in twice as much roof steel. The size of the beam cannot be any larger because it's already at 8 foot. The bottom of these proposed beams would be at 8 foot. Items that we looked at was, for instance, we could paint the units. Any screening that we would try to put up there would have to be over 75% open in order to not hold back the snow.
Okay. All right, Rich, do you have some other comments, or would you be okay with some
I think that pretty well summarizes it.
I guess I'll go ahead and lead off as one of the South Siders here. The improvements.
I do have one other comment.
Sure.
The very first photograph of the submittal is to the west on Park Avenue. It's a large photo number 2. There. Yeah, photo number 2.
Yeah.
That is a 2-story building that you can see all the rooftop units. It's an older building, so it's compliant via that way. But you can see all the rooftop equipment on a building that is over 30 foot tall. So grade does have an effect on being able to see the units. Yeah, that's only a couple blocks to the west.
Okay, so guys, here's a question I've got, and I'll give a statement first. This is a fabulous looking change from what this used to be at this location. I was a fan before going down to Orlando's. Hope to be a fan here coming back. It looks night and day different, and I know you've spent a lot of money to invest in this site. I feel like to a degree you're 99% there already, but what I'm not able to pick up from the photographs, and maybe staff could put the picture up from the Park Avenue view, yes. It looks like on the east side of the old building where the walk door is, it looks like there's a white parapet already, but is that the back building?
That's the back building.
Okay, so this is where on that gray horizontal facade on the original building on the south and east sides, so we don't have any screening on those south and east sides, correct?
We did raise the parapet originally was none.
Right,
Which would be about at the line of the top of the south side letters.
So we added 2 foot high.
We added another 3'6" parapet.
Okay.
And that generated snow drifting that fell within the wall area, so to speak, so that I had support.
Okay.
With the additional documentation that I emailed Monday, I'm now having snow drifting going back 16 to 18 feet onto the existing roof. In order to provide additional support, I had to have a W16 by 21 spanning 32 feet.
Okay, let's come back around and let's get back to a few questions I've got.
Okay.
On the north and somewhat northwest side, it looks like just by viewing this photo that either by design or default, you've got some screening on that north and northwest side. Is that correct?
That is correct, because the snow drifting that comes off of that falls on the new building.
Okay, right. And as good Iowans, we all know that most of our snow comes from the west-northwest. So if it came over that wall, it'd be inclined to pile up on the south-southeast corner of the old flat roof if we had a tall screening.
That is correct, yeah.
Okay. Yeah, I've got you. Okay.
We're between a rock and a hard spot in terms of snow drifting.
Right. And to the best of your knowledge, this is exactly why you designed this the way it was, because you needed an outlet for your snow to be able to blow off this flat roof design, correct?
It is such, yes, that's correct, but it's such that the snow from the new addition would not blow on to be stopped onto the,
Gotcha.
It kind of blows on by.
Gotcha. Okay. Any other questions for Rich or Bruce from anybody else? Okay. All right. Well, pretty well put then, guys. If it's okay with you, then we'll go ahead and see if we have Anybody else that wants to speak in support? Sound okay?
Yes.
All right, thank you, gentlemen. Okay, is there anybody that wishes to speak in support of the applicant's request? And you just got to hit *9 on your phone or the raise hand icon in the Zoom app to be recognized. Anybody else to speak in support?
Mr. Chair, Eric Lundy, Rich Ayers is the only attendee at this point, other than the panelists.
Okay. Oh, yes. Okay, thanks. Yeah. Yeah, okay. So, well, that takes care of that. So, just by default, anybody to speak in opposition? Seeing none. Anybody speak neutral? Seeing none. Any comments from Zoning Board of Adjustment, or from the Zoning Enforcement Officer?
I have nothing.
Okay. Anything from city staff? Questions for city staff, I should say, from the board.
This is Cindy, Mr. Chair. How did this come to the zoning board?
Good question.
To the city, was it a complaint lodged, or how did it get to us?
Good question.
Chair, members of the board, Jason Van Essen, planning staff. So as this has gone through the permitting and inspection process, it became obvious that they weren't going to comply with the zoning requirement for the screening. And so the only way that they can be allowed to not put screening is for the board to grant a variance of that requirement. So that's why it's before you today.
Okay.
This is Nathan. I've got a question for staff too.
Yeah, go ahead.
Jason, when you were presenting, it sounded like you didn't really know what their excuse was, and that was one of the reasons why staff made the recommendation you did. Now that you've heard it, does your recommendation still stand, or is there any reconsideration of that?
Well, what I'd like to hear is more information on what it would cost. I do agree that, with regard to grade, I think that you could provide screening that met the intent of the code with that grade. I don't think that's relevant, but I do understand and believe that there are snow load and structural concerns. But what hasn't been provided, I don't believe, in testimony today is information on the financial impacts or a hardship. And my sense is they probably have that information, but I don't feel like I've heard it yet.
Okay, we'll come back to that.
Am I able to speak?
No, sir. Unfortunately, not. This is for city staff.
Okay.
I think our members can come back to that in our own discussion. Do we have any other questions for city staff? I'm going to go ahead and ask Jason, to the best of your knowledge, by inspecting the site, is the location generally in compliance with all the requirements for where signage is present, lighting on the property, et cetera? Is everything else pretty much up to snuff?
When I was on the site, I didn't have the site plan with me, so I couldn't tell you give a full zoning compliance, site plan compliance report, but I can tell you that it did catch my eye that there's a pole sign along Park Avenue that has no signage on it, that my understanding it lost its non-conforming rights and needs to be removed. But that would be the only thing that I'm aware of in addition to the screening.
All right. All right. Anything else for city staff or questions?
Chair, this is Justin Gross, just for Jason real quick. Maybe I didn't hear it in your presentation earlier, but when the site review was done and the plan was made, did it show any screening in that south side, or was it always shown as not having any screening?
You know, I can't comment on what the building plan reviewer saw on a site plan. Remembering this came in as an administrative site plan under the old code and the old process, we would typically require some sort of note on the site plan, but we wouldn't necessarily see the drawing. And my understanding from talking to the staff that's been intimately involved with the review of this through the entire process is that there has been a little bit of an evolution of what they were going to do for equipment, mechanical equipment on the roof. And so I'm not 100% sure that, that at the point in time that staff has been looking at this, that it was fully understood what was going to end up being constructed up there. So we're kind of coming at the back end to try to fix it.
Okay, thank you.
Okay, any other questions for city staff? Okay, hearing none, we'll turn it back over to the applicant. They can have some rebuttal or closing comments up to 3 minutes. So you guys, you get the last say.
Hello, this is Bruce Erleman again. Can you hear me?
Yes, sir.
Okay. Yes, we are, in answer to questions there, this is the last item on our list before we can get our certificate of occupancy. The design of the building really never changed from the start to the finish. What changed were the mechanical units up on the roof. So what was submitted and what you see today is, or what you see today is what was submitted last October when we got our building permit. So this is the last item on our agenda. We are in compliance with all other code requirements. Everyone else in the city has signed off, and this is the last item before we can get our certificate of occupancy. Thank you, and I'll turn it over to Rich Ayers now, the architect.
Okay.
To answer a couple of your questions in terms of what it would, we have not gotten a contractor price to install these beams, but just the logistics of it. This was an existing building, existing windows, all of that remained. So we would have to remove a window, pass a 1,000-pound beam through the window, position it, raise it up, and then anchor the structure to it and items like that. There are 12 of them, and if you figured, it'd be $1,000, $1,500, $1,000 for each of those beams, you're quickly to a point of it being more than the value of the building. So, it's try to go in and reinforce the existing structure, but it wouldn't make any sense. Part of our goals was to reuse the existing building. We did everything that we could within the available snow loads, things like that for Iowa to raise the parapet as much as we could. We couldn't raise it enough to deal with the slope of the road.
Yeah. Okay. Okay. All right. Thank you very much. What we'll do now is we'll close the public portion, so no more comments, and we'll go to board deliberation, and the board will discuss the merits of the case.
Hey, Mel.
Okay. Yes, sir.
Hey, this is Dave. If you're ready for comments.
Yeah.
I asked Jason earlier in his presentation. The shielding is a requirement that the city has. Period. Right?
I'd say yes.
Mm-hmm. Okay. The fact that wasn't part of the original drawing, I don't know, that were submitted, I don't understand why we wouldn't be questioning that right from the beginning, but it is what it is. I don't have any sympathy for what the topography dictates as far as the view. It is what it is. And if you can see the mechanical, you see the mechanical. Also, there was existing, I think it's great that they wanted to use the old building and restore that. Plus, that saves them some money. I get that. But there was mechanical on the existing building. They just upgraded it with new mechanical. So I don't look at the evolution of the mechanical equipment. So they need more vents or hoods or whatever for the kitchen. That's a given. So I don't think any of that's a real logical excuse either, as far as this whole thing goes. The construction could have been done when they were doing the demo way back when. So now they're having to go back and redo it. The building's finished.
Yeah.
So, I mean, having said all that, I guess I'm just raising some questions about some of the reasoning behind why we're where we are.
Okay.
Having also said that, I guess the snow load, they did state that they need to have some kind of a shielding that's going to be 75% open so that the snow can pass through it, which I don't know what that's going to look like. Is that a wrought iron fence that goes around there? Might look worse than nothing at all. I don't know. I think one of the solutions they've offered is to paint the mechanical, which I would be inclined to go along with.
Yeah.
I think one of my thoughts is we're kind of in a spot here that I think we could have avoided being in the beginning. And now what we're getting is we're getting a bunch of excuses about why we're not doing it.
Right.
So those are just some of my thoughts. Making a motion, I think we sometimes get in these conundrums on some of these issues, and I feel like we could have headed this off at the beginning.
Okay.
A little bit. So that's it.
All right. Other thoughts? Anybody?
Mr. Chair, this is Cindy. As you indicated, this is a great improvement to this area. The building that was there before was not kept up very well, so this is really a nice improvement for the south side and for this area. And I'd be inclined to go along with the idea of just having them, paint the mechanicals. That might kind of give it a nicer view.
Right.
And I know for some of the folks in the apartments across the street on the second or the third or the fourth floor, I'm not exactly sure how tall that building is. It's not too tall, but they're going to see rooftop regardless.
Mm-hmm.
And I think the applicant has expressed the needed hardship for what it would take to have to pretty much reconstruct or redo the entire original building in order to get this done. And then there's still issues with the snow load.
Right.
Even that would fix it. So it just makes the most sense for me to, approve the variance and ask the applicant to paint the mechanicals and keep them painted so they look good. And I have faith that would happen.
Okay. Good comments. Other thoughts? Anybody else?
This is Nathan. I think they made a decent case. They go back to kind of what Dave was saying, is that they know the requirements from the beginning, and they kind of put themselves in this pickle, right, by insisting upon, certain design decisions and building decisions that put them in this position where it does sound like there's some hardship associated with it, although I don't know that they've even made the case solely for kind of a variance level hardship where they show that no reasonable return at all can be received from the site. But, there are things with the land itself, I suppose, that play into this, but they made lots of decisions along the way, with full knowledge of the city's requirements about shielding things on top of the roof. And so, I don't know, I guess I'm having a hard time coming around, even though it feels, it feels somewhat unjust to just insist upon it. On the other hand, there are all sorts of ways they could have avoided it, it seems to me at least,
right.
up to this point. And it's not like this is, this is like homeowner X who doesn't do building stuff ever, right? Like, it's a relatively sophisticated person and entity who's developing something that's in their line of work and should know all the requirements and have to plan for them appropriately.
Right. Yeah. Okay. Other thoughts? Okay.
Here, if I could say something real quick. I sort of concur with Nathan and Dave on this one, and I feel like if the applicant would have came with maybe some hard numbers or some estimates showing the financial hardship, I might have been inclined to see it as as a hardship, but I haven't seen that, so I am going to be voting against the variance.
Okay. I'm just going to throw in here a little bit, and I want to extend my thanks to everybody. We always think through these issues, and everybody brings up very good points to consider. If this was easy, it wouldn't be in front of us. It would have been dealt with. This is not the first case we've had in front of us about screening of rooftop mechanicals. I like to consider the merits of each case on the merits of each case, and I don't usually look at precedent or anything like that unless that's been put into code. But there seems to be a trend where people aren't aware they're supposed to be screening their mechanicals. It either doesn't show up in a site plan, doesn't show up in a profile drawing, and then we get to the end of the line and, oh my God, it's not there. You can't claim ignorance of a regulation because you didn't read the regulation. But I would encourage city staff to find a way that if there are these very important things that are more than where an exit sign is positioned or something, that these very important things to deal with site plans are clearly dealt with during site plan review. If people have to submit a physical site plan that shows how things relate to each other on the property, including height of buildings and style of buildings, then this needs to be clarified. So I want to encourage staff to do a little homework on that so that we can avoid this, because maybe this could have been designed at that time. That said, on the flip side of the coin, the applicant in this case, with what they've constructed, they effectively have screening on probably 2/3 of the perimeter of this building by the design of the addition. There's very little left here. And as I think it was Cindy noted, the taller buildings are always going to look down and see it to a degree. But I don't believe the zoning ordinance requires screening from any view. I think it requires screening from the ground level view or this, quote, street view. So to that degree, I don't think we're too far off the mark if we could look to find a way to maybe look at meeting in the middle. I do think on an existing older flat roof building, yes, they might have a problem installing further materials. I'm not here to challenge what an engineer says about thickness of beams and loading and dimensions and how all that would work. So I'm going to take that at face value. And I would say that's a pre-existing condition of the, quote, land in question. The structure itself would not be amenable to put this up. And if he's given me a bluff, well, then he's got to look in the mirror. But from what he told me was snow load and weight load of more stuff, that's not going to work. The applicant clearly stated from square one he was willing to paint all the mechanicals to match the color, the white color of the other parapet. I would be in favor of allowing that. And we've done this before too, to make sure there's other non-compliant things are also removed. A little bit of a quid pro quo here. I'd like to see the non-compliant sign base or sign pole out of there. But that is just my comments of the 4 to 5 here that have already been presented. So if somebody does have a motion one way or the other, if there's other comments, great. If not, maybe it's time to make a motion to see which way this is going to go.
Okay, I'll make a motion. I think there's an agreement.
Mr. Chair, this is Cindy Smith. I'd like to move to approve the variance.
Okay. We're also getting a little feedback. Does somebody have their speakerphone on as well as their laptop microphone?
Mr. Chair, this is Eric Lundy. I believe Lynn actually initiated a motion before Cindy.
Cindy can have it.
Okay.
I didn't hear Lynn's motion, so if it's the same motion, then it doesn't matter.
Okay, so well, one of you can second the other. If Lynn was first, was your motion to just grant the variance? Were there any other conditions or any other amendments?
With them pinning the mechanicals or the things that show on the roof right? And you mentioned non-compliant signs.
Yeah, there was an expired sign base, a pole sign.
And have them remove that.
Okay, so that's your motion with those two additional conditions to grant the variance?
And I'll second that, Mr. Chair.
Okay, Cindy sounds like she's in favor of those extensions. All right, so we've got a motion and a second to grant the variance with those two conditions about painting the mechanical units white or color that matches that, and removing the non-compliant pole sign and base. All those in favor of the motion, we'll take roll call.
Nathan Blake. Nathan Blake.
Nathan's muted somehow, it looks like.
Mr. Chair, I can't unmute him.
Sorry. Okay. Yeah. So board members, you can unmute yourself at this time, all of you, so we can take roll call.
Nathan Blake.
Sorry. I'll be honest. I got pulled away on a different phone call, and so I missed the motion.
I'll give it to you briefly. The motion is to grant the variance, however, with amended conditions that requires painting of the mechanical units white or that matching color to the rest of the parapet of the building, and removal of the non-compliant or non-conforming pole sign and base on the property.
Okay. I'm going to vote no.
Okay, all right.
Lynn Carlson.
Yes, aye.
Dave Gare.
Aye.
Justin Gross.
No.
Marlis Jones.
Nay.
Cindy Smith.
Yes.
And Mel Pins.
Aye.
I got motion passes 4-3.
Okay. All right. Well, Bruce, I wish you well with your business endeavor down here in this part of town. We look forward to coming in to visit you.
Thank you very much, Mr. Chairman.
Okay, well, I think that includes all of our agenda items for today. I want to thank my colleagues for all their time, as well as city staff for all their support to conduct this hearing online. So I don't believe we have any other further business, so this hearing is adjourned. Thank you all and have a good night.
Goodbye.